I'm the chairman of Brodies, and welcome to our 6 months to Brexit Seminar. Thank you very much for coming along this morning. Welcome also to our remote audience. We are being live streamed on social media this morning, but not to worry, that shouldn't affect you in any way, shape or form. We are going to halt the live streaming when we come to the end of the presentation, so that if you feel in any way ashamed or embarrassed about any questions you want to ask, it's only this room that will hear those and our live streaming audience will not. I'm joined this morning by my partner Charles Livingstone, who's also a partner in our Government Regulation and Competition team, and by Hannah Frahm. Hannah is a professional support lawyer who's been working in our team for about 6 months on only Brexit, and she remains cheerful notwithstanding that is the case. We haven't had a Brexit-related seminar for clients in quite some time, and we've not had those seminars because we've not had very much to say, and we knew that if we held a seminar you might ask us what's Brexit going to look like after March 2019, and we wouldn't be able to tell you the answer to that. We still can't tell you the answer to that, but with 6 months to go, we're very conscious that there is a bit more appetite, I think, around for information about how the Brexit process is going to play out and what that might look like when we get to March. So that's going to be the focus of this morning's seminar. There was quite a lot of debate about whether we should use this slide as part of this morning's presentation. There was a concern that it might be a little bit too political, and we're definitely not in the business of being political. I made the decision that we would keep this slide, partly because it's quite funny and you've got to take your Brexit-related humour where you can get it, but also because it does reveal for us what we hope to do this morning, which is, I'm afraid, to bore you with a little bit of detail and to demystify some of the language and some of the concepts that are being talked about in the press, talked about by politicians, but not necessarily always being talked about meaning exactly the same thing. So we will bore you with a bit of detail, I'm afraid. What we're going to do is to talk a little bit about why the 29th of March 2019 is a significant date and what that actually means for the Brexit process. We'll then go on to talk a little bit about the Brexit negotiations and what the concept of a deal is, because we hear a lot about a Brexit deal and a no deal scenario. We're going to try to explain what we think is meant by those expressions. Then to say a little bit about what might happen if indeed there is no deal done. And finally, if we have the time, just touching on the peculiarities of Scotland, if you like, in the Brexit process. So why is the 29th of March 2019 of significance? Well, you'll remember if you've been to these seminars before that Article 50 of the Treaty on the Functioning of the European Union provides that a member state who wishes to leave the EU can give notice of its intention to do so, and assuming everything remains equal, that member state will leave the European Union 2 years after the date on which notice is given. That date can be extended, and we'll talk a little bit about how that might be done. And indeed, the date could be foreshortened if an agreement on exit was reached before the end of the 2-year period. That doesn't seem highly likely at the moment, so we're anticipating that having given notice on the 29th of March 2017, that is to say the United Kingdom, will leave the European Union on the 29th of March 2019. The United Kingdom will leave at 11 p.m. UK time, because that will be midnight in Brussels. That's not film noir, that's just a reference to the time in the EU on that date. There are a number of scenarios in which we might find ourselves on the 29th of March 2019. We have chosen 4. We suspect there may be others, but these are the 4 scenarios that we propose to mention in this session this morning. The first is that there is a deal, and that's the first expression we hope to explain in a bit more detail. What do the politicians mean? What do we think they mean when they refer to a deal? Well, in terms of a deal, what we understand is that they mean that there will be a withdrawal agreement finalised between the European Union and the United Kingdom. That will be concluded by the 29th of March, and will come into force at 11 p.m. on the 29th of March next year. At that point, the United Kingdom will formally leave the European Union, but all going well, and if a withdrawal agreement is concluded, there will be a transition or implementation period. The EU calls it transition. The UK government has up until now called it implementation, but there will be a further period until the 31st of December 2020. We will be out of the EU, but we will be behaving, and the EU will be behaving to the extent that we all can do that, as though we were still in the EU until December 2020. So that's what a deal would amount to. What does leaving the EU mean? It means, in terms of Article 50, that the treaties, the European Union treaties, cease to apply to the UK. That's what leaving amounts to. Another possibility is that there is postponement of withdrawal of the United Kingdom from the European Union. Now, that could happen whether we have a withdrawal agreement agreed or not. So we could have a withdrawal agreement but decide that it's not going to come into effect on the 29th of March 2019, and we're going to postpone our exit from the EU. Or, because we don't have a withdrawal agreement, we could agree that we're going to continue to negotiate and postpone our withdrawal from the EU. As you will all know, there are political reasons why it may be difficult to postpone withdrawal from the EU, but it is a possibility. Then you will have heard a lot about a no-deal possibility. What is no deal? Well, we understand that no deal is a situation in which there is no withdrawal agreement between the European Union and the UK, but notwithstanding we don't have an agreement, we nevertheless leave the EU because our 2 years is up. So that's what a no deal amounts to. We leave the EU, and this is quite important, in that scenario there would be no transition or implementation period. So laws would change, our status would change immediately on the 29th of March 2019. We wouldn't be pretending effectively until December of 2020 that we were still members of the EU. So I think there may be misunderstandings about what a no deal involves, but people shouldn't assume that a transition period is guaranteed. If there is no deal, then there may be no transition period at all. And that's what the reference to hard Brexit tends to refer to. And then the fourth, at least theoretical scenario, is that the United Kingdom doesn't leave the EU at all. That doesn't, again, feel like a very likely outcome given the nature of politics at the moment, but it's at least something to be aware of as a possibility. And again, you may have read in the press of a decision of the Scottish courts last week to refer to the European Court of Justice in Luxembourg, a case brought by a number of politicians in the UK, including members of the Westminster Parliament, to ask that court to rule on whether the UK can legally withdraw its Article 50 notice. Now, that may not matter if nobody wants to withdraw the Article 50 notice, but the question is being asked of the Court of Justice in Luxembourg. So those are our four possible scenarios, and we are going to start by looking at the first of those. What might a deal look like if a deal can be reached? That's quite hard stuff to think about, and because it's a bit tricky, I'm going to step aside and let Charles do the heavy lifting.
Thanks, Christine. So in terms of breaking down the deal scenario, we're going to say a little bit about what needs to be agreed before we have a Brexit deal. So what is it that goes into this withdrawal agreement and gets us to that transition period? Where do we stand at the moment? I will then speak a little bit about why the negotiations are proving problematic, covering some of the key points. And then hand back to Christine to talk about timing issues. So when might the deal be finalised, and as part of that, how would the deal be ratified, which is relevant to the timing question. What is it we're trying to agree? So this on the slide, and hopefully it's visible to our online audience. This is part of the text of Article 50, Treaty on the European Union. So this is, as Christine mentioned, the article under which the UK has given its notice to withdraw. So that covers the first paragraph and the first sentence of the second paragraph. And the bit that we've put in the box there, that's about what happens once that notice has been given. So the union and the member state who is leaving negotiate and conclude an agreement setting out the arrangements for withdrawal. So it is limited, this agreement is limited to the terms on which the state withdraws from the union. But there's then that second part that this needs to take account of the framework for its future relationship with the union. And the thinking there is that the EU takes the view that legally the EU and the member state can't enter into a binding treaty until the state has left about the future relationship. But you should have a sense of what the future is going to be in order to decide on what the terms of withdrawal should be, because the future relationship should inform the basis on which you withdraw. You set up if you're having a transition period, which obviously is the plan here, you set that up in a way that you know what you're transitioning to, and the transition helps with that. It's not a legal requirement to have an agreement on the future relationship, but there is a strong political incentive, at least on the UK side, to have an idea of what the future relationship, the trading relationship in particular, is going to look like before agreeing on withdrawal. In particular, the UK is not going to be keen to hand over almost £40 billion worth, or agree to hand over almost £40 billion to the EU if all they know they're getting in return for that is the transition period with no visibility on what's going to happen in the longer term following that. There are also issues relating to the terms of trade and cross-border cooperation between Northern Ireland and the Republic of Ireland. That's the sort of sharpest manifestation of issues that apply generally to the UK and the EU, but for reasons I'll cover, they are most acute when it comes to Ireland. But the future relationship point and the relationship it has to agreeing the terms of withdrawal is probably a bigger issue for the UK than it is for the EU. If the EU gets a withdrawal agreement and a transition period, it doesn't particularly matter to the EU what the future relationship is going to be, because the EU gets the money at the point withdrawal is agreed. It matters a lot more to the UK to understand what the future relationship is going to be before that money is signed up to be handed over. So, where are we now? Well, in March of this year, there was a draft withdrawal agreement published following the what we called the Phase 1 negotiations. So these are the negotiations on the terms of the withdrawal agreement before anybody even moved on to the future relationship. And there is a briefing on those Phase 1 negotiations just outside the room on the table. You'll find some of our Brexit materials there. It's also on our Brexit hub on the website, which is easily found on brodies.com for the benefit of our online audience and anyone who doesn't want to take hard copies with them. So the withdrawal agreement has been published in draft. You'll see that the text that's up there, the first article, that is highlighted in green. That's not our highlighting. The agreement actually features highlighting. If something is highlighted in green, it is agreed. So at the very least, we can see that the parties are agreed about what the agreement does, which is good. There's also highlighting in yellow. That's where there's policy agreement, but the language is still subject to negotiation. And text that is not highlighted is text that has been proposed by the EU and the UK has not agreed to. So those are the areas that are still in dispute. Now, the figure that's given for how much has been agreed is 80%. I'm not quite sure how that's calculated, if it's qualitative or quantitative. Certainly the sticking points are pretty substantial, so that's presumably a quantitative assessment. So things that have been agreed in principle, the transition implementation period, citizens' rights about continued free movement during transition and rights to reside after that, and the financial settlement. Those are all pretty much pinned down. But there are important issues that remain unresolved. Again, I've already mentioned Ireland. That's in quotes there. Obviously, Ireland and Northern Ireland will both continue to exist. It's about the status of trade and cooperation between them and how that would work. The future customs arrangements and the trade relationship. Now, again, these are the point I mentioned about the future relationship, but we need to have some clarity, or at least we want to have some clarity on that before the withdrawal agreement will be or can be agreed. So the key principle for the withdrawal agreement is that nothing is agreed until everything is agreed. So even if something is in green, as Christine was saying, things like the transition period, they are only agreed in principle until this agreement is pinned down in every particular. So until the agreement as a whole is finalised, including the very sticky issues that I'm about to come on to, there is no agreement on anything. So the key issues. I don't know if anybody is familiar with the Irish Border's Twitter account. Obviously, it is a satirical account. Its description of itself is that it is the border between Ireland and Northern Ireland. I'm seamless and frictionless already, thanks. Bit scared of physical infrastructure, which obviously is a very glib approach to a very serious issue, but it does illustrate that that this is, as I said, the key manifestation of the future relationship issues. The reason that Northern Ireland and Ireland has become a real focus is that at the point of Brexit, the UK is obviously a non-EU country, which means that at that point, that is a land border between the UK and the EU, and it is part of the EU's external border. And the EU does not have any open external borders. It applies tariffs at its external border. It applies regulatory checks, not necessarily for all goods, but certainly for things like the movement of animals, agricultural products, plants, that sort of thing. These are things that are checked at the EU's external border. So if the border between Northern Ireland and the Republic of Ireland is going to become the EU's external border, you need an agreement on how things are going to operate there if you're going to avoid the sort of infrastructure that needs to be done, that is done, for example, on the Ukrainian border with Poland or the Greek border with Turkey, in order to establish the integrity, as the EU refers to it, of its external border. So there are really two key issues when it comes to these checks, the single market and the customs union. So it might be worthwhile just breaking those down slightly with the use of this handy diagram. You can see from the hyperlink that's given there, this is not ours. We have not spent days and days producing this. It's from Wikipedia. But it is very helpful, and hopefully this will be up on the screen for our streaming audience. It's very helpful in understanding what the various relationships between countries within Europe are. So hopefully everybody will recognise the UK flag, if none of the others. What you can see there is that the UK is currently inside the EU, obviously. That's the blue box that says European Union on it. It's inside the EU Customs Union, which is the orange box. And it's also inside the EEA, which is the European Economic Area. And that is the purple box. So in terms of relationships that non-EU countries have with the EU, the two that are most important for what we're discussing here are Norway and Turkey. If you don't know those flags, Norway's is the third one down on the left. Turkey is the one at the top above the UK flag, which is the white crescent and star on the red background. So starting with Norway, Norway is inside the European Economic Area but outside the EU. Now that's often taken as a shorthand for Norway being in the single market. The single market is the collection of rules that the EU imposes in relation to things like products, like the transportation of live animals, also things like social and environmental standards. So Norway and the other EEA countries, Iceland and Liechtenstein, they sign up to those. They basically say, we will adopt those rules. And in return for that, Norwegian goods get preferential access to the EU in the sense that they don't pay tariffs. Because they agree to adopt all the EU's standards, they're not subject to the same regulatory checks that goods from other countries are subject to. So that deals with at least some of the border issues, but it wouldn't deal with all of them. The reason for that is that the EEA countries don't actually have free trade with the EU in agricultural goods. So there are still tariffs and quotas for agricultural goods between Norway and the EU. Obviously, that is a big part of the trade between Northern Ireland and the Republic of Ireland, a lot of agricultural movement there. So the approach that Norway has wouldn't solve that. And the other issue with being in the EEA you'll see that Norway, the flag is not in the orange box for the EU customs union. And if you don't know what a customs union is, the best way, I think, to think about it is if you imagine a sort of medieval city-state that's surrounded by a high wall with a number of gates. When people bring their goods to that city to take them to market, whichever gate they use, they pay the toll, they pay the tariff to get their goods into the city. But once they're in the city, those goods can circulate freely. That's basically how a customs union works. The point at which goods from any other country enters any country from the customs union, it pays the same tariff, whichever port it uses to get those goods inside the customs union. And then once those have been paid, they circulate freely. So that's the position that Turkey is in. Turkey is in a customs union with the EU, and that means that goods travelling from Turkey to the EU don't need to have any tariffs paid, and they don't need to go through what we call rules of origin issues. That's the problem with Norway being outside the customs union. Norway has its own free trade deals with other countries, which means that in some cases the EU and Norway apply different tariffs to those countries. So a story from a few years ago, the EU imposes high tariffs on garlic because there's a lot of garlic grown in the EU. The Norwegians don't grow their own garlic, so they have a much lower tariff on garlic. So garlic was coming in from China to Norway, paying the lower Norwegian tariff, and then being smuggled across the border into Sweden, which is in the EU, thus circumventing the EU's garlic tariffs. So if you're not in the customs union, you still have to have border checks to avoid that sort of smuggling. But being in the customs union by itself for Turkey, Turkish goods, they don't pay tariffs, but they are subject to regulatory checks because Turkey's not in a single market. You'll see that there is no country that's not in the EU but is in both the EEA and the customs union. There is no country in that situation. So the sort of off-the-shelf proposals for relationships that the UK might just slot into in respect to the EU, they don't work for the purposes of the Irish border. Or generally for the concept of completely frictionless trade between UK and EU. And that's illustrated by this slide, which was produced by the Commission, which illustrates why the various existing EU relationships within Europe are not compatible with the UK's red lines. So the first one indicates EU membership. That's incompatible with leaving the EU. We then have the EEA countries. Well, why isn't that acceptable to the UK's red lines? Because it requires accepting Court of Justice jurisdiction, more or less. Requires accepting free movement, including of people. Those countries make a substantial financial contribution to the EU, and they do not have regulatory autonomy. So the UK wants to avoid all of those things. We then have Switzerland, which is not in the EEA but has a lot of free trade agreements with the EU that to a certain extent replicate the same thing. That doesn't work for the UK's red lines because we want no free movement of people, no substantial financial contribution, and we want regulatory autonomy. So that arrangement doesn't work. We then have the Ukraine, which is in an association agreement, but that is about converging the regulatory regimes of each country, including or of each territory, including accepting Court of Justice jurisdiction. That's a no-no for the UK government as well. And then we get to Turkey being in the customs union. That's not acceptable by reference to the UK's red line that we want to have an independent trade policy and reach our own free trade deals, which Turkey can't do because when you're in a customs union, you all have to abide by the same trade arrangements. And from the Commission's perspective, that means that if you comply with all those UK red lines, where you get to is a free trade agreement along the lines of Canada and South Korea. The difficulty with that is those relationships don't provide for completely frictionless trade of the sort that is desired in the island of Ireland in particular, and nor do any of the other arrangements as you work your way back up the ladder. So if that is also a red line, what you have is a collection of red lines that are actually very difficult to reconcile with each other and are very difficult to deliver altogether. So what the UK is trying to do is come up with something bespoke. Say, we're not interested in any of the off-the-shelf options. We've come up with a different plan that will comply with our red lines and also comply with the desire to avoid a hard border in Ireland. And that gets us to Chequers, sometimes also referred to as the Brexit White Paper. And on our Brexit Hub and in our materials outside, that's how we refer to it. So if you're looking for our material on Chequers, look for a Brexit White Paper. The key provisions of Chequers is the proposals, or are the proposals that the UK will follow, or that the UK and EU will agree what's referred to as a common rulebook for all goods, including agri-food. So this is kind of a Norway plus arrangement in respect of goods, and a commitment to, I should say, continuous harmonisation with EU rules. So Chequers refers to it as a common rulebook. It's really the EU's rulebook. It's the UK saying we will abide by all EU rules in respect of goods. Chequers is much less committal on services. There's no suggestion that the UK would abide by all EU rules on services. This is about goods because it's the movement of goods that creates the requirement for border infrastructure. Chequers seeks reciprocal commitments on open and fair trade, looking for a joint institutional framework to interpret the future trade arrangement. So that would be essentially international arbitration mechanism to decide on disputes between the UK and the EU. What's called a facilitated customs arrangement for a combined customs territory. So this is kind of a halfway house towards a customs union, in the sense that the UK would apply the EU's external customs tariff to all goods coming into the UK. But then if anybody was entitled to a lower tariff rate in respect of use in the UK, they would be refunded the difference because they hadn't shipped their goods onto the EU. If that sounds complicated, it is complicated. And it is both hard to explain and hard to imagine working in practice. And certainly that's the EU's position, that it is both logistically very difficult, and they have an in-principle objection to it, on the basis that the EU doesn't outsource enforcement of its own customs territory to countries that are not part of the customs union. Chequers proposes an end to the free movement of people, but in its place proposes a mobility framework for people moving between the UK and the EU for various purposes, and a briefing on the mobility framework is outside if you want to pick that up. So the EU's principal objections are to the customs arrangement, and also they're not happy with the common rule book on the basis that it would split up the EU's single market. Now, they don't object when another country adopts its standards for products. So if a third country says we're going to adopt the EU rules standards for the making of toasters and kettles, the EU doesn't object to that, but it doesn't necessarily give that country the right to send goods into the EU without inspection. So their toasters and kettles still get inspected to make sure they're compliant. And in particular, so does their agricultural produce. So it's really that point about the right to move goods that the EU objects to, and also objects to conferring that right to move goods on a country that respects its standards but wouldn't be complying with social and environmental protection standards and that sort of thing. So the EU is worried about basically being undercut, not necessarily financially, but in terms of the cost of producing products if the UK adopted lower standards in those areas. So we're now going to move on to the timing for a deal.
And it's a slightly obvious point, we're quite short of time. Okay, so this is a slide that was published by the European Union earlier in the year, and on the far left-hand side we have March 2018, and on the right-hand side we have March 2019. And this was the European Union's expectation about how the negotiations might go and when we would get to conclusion of a deal. There are two blocks. The yellow block denotes the negotiations over the withdrawal agreement itself, so what's known as the divorce, and the green block denotes the negotiations over the future trade relationship that the EU would have with the UK, because that doesn't need to be concluded at the same time as the withdrawal agreement. And the expectation was that somewhere between June and October of this year we would get to the final terms of a withdrawal agreement. And then the right-hand side of that, the sort of sky blue box, describes the ratification process that would be undertaken by the EU, leading to a finalised agreement by March 2019. In terms of the green box, what was expected is that we would get to, again in October 2018, a political declaration by the EU and the UK about the future trade relationship. And what would happen after March 2019, during the transition period, is that the EU and the UK would continue to negotiate about the future trade relationship. You will see that there is a white broken border in the middle of June called stock taking. I take that to be the European Union's summer holidays, and I think they anticipated that by their summer holidays they would have the final bones of a deal negotiated. People could take a rest and we would come back in October and there would be a pleasant sort of experience of everyone saying how good it was to have reached a concluded withdrawal agreement. The point being that from the negotiation perspective, we're bunching everything up at the end of this process, and where we are now is having the European Union saying that they expect maximum progress to be made at the October summit, which is anticipated, and if progress is made, and if they're confident that enough progress has been made, there may be an emergency summit in November or an extra summit in November to conclude the outstanding details around that agreement. So that's from the European Union's perspective. I'm not going to spend time on how the agreement would be ratified at an EU level, because actually, even if we get an agreement, ratification at the UK level is more complicated and potentially more difficult in terms of formalising a deal. So let's assume the negotiators get to an agreed final text. What happens then at the UK level? And this will be, I'm quite certain you will see machinations in Parliament from now until January around any deal if a deal is done. If a deal is done, before the UK is bound by it, several things need to happen. And the first thing that needs to happen is that there needs to be political approval of the agreement in the Westminster Parliament. So there has to be approval by the House of Commons in what's called a meaningful vote. You may have heard of the meaningful vote provisions that were included in the European Union Withdrawal Agreement bill at the end of the summer. They give the House of Commons the power to debate and agree or disagree the terms of any final agreement, and it's anticipated that any approval by the Commons could be made the subject of conditions, including, for example, a condition on a second referendum on that deal. So that's the meaningful vote. There has to be a parliamentary process to approve the deal. The House of Lords also gets to vote on it, but it has a much less meaningful vote, if I can put it in those terms. It takes note of what is being done. If that parliamentary approval is given, the UK government then introduces a piece of legislation into the Westminster Parliament called the European Union Withdrawal Agreement Bill to give legal effect within the UK to the terms of the agreement. And again, as you can imagine, it's for the UK Parliament to decide as a whole whether it is going to pass that bill or not, and whether it's going to, for example, impose conditions such as I mentioned, the possibility of a second referendum on the deal itself. If that bill is passed, there is a further procedural hurdle to be gone through under the Constitutional Reform and Governance Act of 2010, which is about ratification of international treaties. And only then, if it gets through that process, is it ratified by the UK at an international level. And I think it's important for you to be aware of all of this, because the focus at the moment is on reaching a deal with the European Union, but clearly the UK government then needs to get any such deal through the United Kingdom Parliament. And it remains to be seen whether they will be able to do that. And of course that then leads to the question of what happens if either no agreement is reached at an international level between the EU and the UK, or a deal is reached but the UK Parliament fails to approve that deal. And Charles is going to start on the no deal scenario.
Okay, so what do we mean by no deal? So as we've been saying, we're principally talking about a deal on the withdrawal agreement. So what we mean by no deal here is that there is no deal on a withdrawal agreement, no transition period or implementation period. There is potential for a subsequent no deal after that. So you might get your withdrawal agreement and your transition period, but then fail to get a deal on what should happen after the transition period. So if we get a withdrawal agreement, you kind of park that point. for about 20 months, and then the arguments start all over again, essentially. But we're focusing on what if there's no deal as of March 2019. Even that phrase, no deal, has within it a few different possibilities. You have a more civil version of no deal, in which everybody thinks, well, we've just reached an impasse here, we're not going to get a consensus, we're just not going to get a withdrawal agreement, so the UK is going to leave in March 2019. But we still want to do sensible things like making sure planes can continue to fly across the different territories, making sure data can still transfer between the territories. So you might, in that sort of circumstance, get side deals on those sorts of things. The alternative is sort of somebody turns over the table, storms out, and nobody's talking to each other anymore. In which case, you're talking about a real hard Brexit with no arrangements there. In which case, you get on to WTO issues, which Hannah may touch on briefly, but are generally very complicated, and we're not going to get into them here, or at least not yet. When will we know if there's not going to be a deal? We don't know. It may be very late in the day. EU negotiations, both with other countries and negotiations within the EU between its members, have a tendency to run to the very last minute. So it is possible that unless somebody walks away sooner, negotiations may continue right up to pretty late. What that means for the whole ratification process that Christine laid out is an open question. You can compress parliamentary time periods, have emergency legislation, that sort of thing, but it would be a real scramble. So the later it gets, the more difficult it would be to implement. But there really is no sort of definite cut-off date past which it is just too late to get a withdrawal agreement. The question is really how much more difficult it becomes to put it in place the later it gets. And what will happen? Well, we don't know for sure, but recently we have at least had some information that will let us anticipate certain things. So the UK government, I'm going to talk about the UK preparations, and then Hannah will speak about the EU ones. UK preparations for a no deal. You'll have seen recently that the UK government over the last month or so has been publishing what's called its technical notices, which are basically sectoral guidance documents about what will happen in a no-deal scenario, or what the government proposes to do in a no-deal scenario in relation to various things. It's said it's going to publish 80, it's published 77 so far. Various topics relevant to various sectors. Some of them are fairly woolly, don't give a lot of detail, but they at least give a sort of a policy indication, so help narrow the possible range of outcomes from infinite to a smaller number than infinite. Others are pretty detailed and do give a fair amount of information on how certain things would work in the event of a no deal. An overview briefing on these technical notices is available on the hub and outside. But in terms of the specific notices, some examples that we have covered on our hub include state aid, VAT for cross-border movement of goods, data protection, and financial services. So for financial services, whether there's a deal or not, there's a proposal to have a temporary permissions regime for any EU firms that are currently doing business in the UK by virtue of the EU's passporting rules. Those passporting rules are not going to survive Brexit. Neither side is proposing to keep them. So what the Treasury is consulting on is an approach that will create a sort of 3-year safe harbour. So any firm that's currently passporting into the UK can apply for this temporary permission. They then have 3 years to get themselves authorised as a UK entity under the UK's own rules. So some of these notices are pretty detailed and do give businesses a basis for at least some contingency planning. There are also other examples that we haven't yet produced briefings on, like life sciences, what will happen to cross-border legal cases and disputes, environmental protection, satellites and space, studying in the UK or the EU, and workplace rights. So there are lots of different things that are covered. There's then the European Union Withdrawal Act. That became law in July. You might remember there was a lot of controversy about that being passed without the Scottish Parliament's consent. There's a briefing on that outside as well. Christine will come back to that later. What will that Act do? Chiefly does two things. You might recall it being referred to when it was still in its infancy as the Great Repeal Bill, because it repeals the European Communities Act 1972, which is what applies EU law within the UK. It is going to repeal that, but at the same time, it's going to take pretty much the entire body of EU law and incorporate that into UK law. So every EU regulation, every EU directive, every decision of the Court of Justice, every decision of the Commission, all of those things will become UK law at the point of Brexit. Now, you don't need to get too much into the detail of that. That's something that us lawyers will be wrapping our head around, I suspect, for years to come. But the second thing that the Withdrawal Act does is for those bits of EU law that won't make sense or wouldn't work in a post-Brexit environment. So, for example, where it requires a public authority to submit a procurement report to the Commission or to put a procurement notice in the official journal of the European Union. You're not in the EU anymore. Why would you do that? So the notices under the Withdrawal Act can be made by the government, both the UK government and the devolved governments, to say the legislation will, instead of saying official journal of the European Union, will say Public Contracts Scotland website, for example. That's where your notices go from now on. So those sorts of technical changes, also some wider changes. So the temporary permissions regime that the Treasury is consulting on is going to be introduced by a Withdrawal Act order. So there are sort of little technical changes. There are also changes being made under this Act that involve significant policy decisions and significant policy and practical changes. So again, we are producing material on these notices as they're being produced, and it's worth keeping up to speed with those that are relevant for your sector. Those notices are not just for no deal. If there is a no deal, they will all be required. If there is a deal, they will all be postponed to the end of the transition period, because we'll all pretend that EU law still applies as if we were a member. But even if there is a deal on free movement of goods, for example, there are still areas that will not be covered by that deal, where we will still need some of these notices. So worth keeping abreast of those, and that's certainly what we're doing. The UK has also passed other legislation where it's too big an issue to deal with through a Withdrawal Act order. So things like nuclear safeguards, haulage permits and trailer registration. And there's other legislation coming down the pipe on things like taxation of cross-border trade. In fact, the trade bill itself, as well as expected bills on things like immigration. So there's lots going on, lots that will change, but there are things that are being done that will give you visibility on what those changes will or might be. So we will certainly be keeping abreast of those and producing material to explain that. Now Hannah's going to cover the EU's preparations.
Thanks, Charles. As you can probably tell from my accent, I'm the only EU 27 citizen here today on this panel. So I'm going to talk to you about the EU preparations for a no deal. The European Commission has published a number of preparedness notices, 74 in total. They cover a wide range of policy areas and topics such as the future of e-commerce, EU eco-label, the EU domain names, professional qualification, and air transport. They're quite similar to the UK's technical notes, although it might be probably fair to say that they are less detailed and more practical, considering that the EU doesn't have to change its whole EU rulebook after Brexit. In addition to the Commission papers, the EU decentralized agencies and the European supervisory authorities have published guidance papers and information as well. Despite the similarities between the two sets of no-deal notices, both sides seem to use the no deal for different reasons. So while the EU, it seems like the EU is using the no deal scenario to increase pressure on the UK government And the UK government seems to prove with their intense preparations that they're ready and prepared to just step away in case the EU pushes too hard. Leaving politics to one side, though, it's at least questionable whether the EU would be able to enforce these repercussions after Brexit due to their WTO obligations and even EU law. Moving to the second point on the slide, legislative proposals. The UK has its Withdrawal Act, and Charles talked about that. And the EU as well is preparing to ensure that the future EU 27 legal framework is and remains fully operational after Brexit, remedying the negative impact of a no-deal scenario and enabling legislation to adapt are the two main goals. A good example here is the relocation of UK-based EU agencies. You might know that the European Medicines Agency is going to be relocated to Amsterdam, and the European Banking Authority is going to be relocated to Paris. Last but not least, the individual member states are preparing them as well. And now back to Scotland and to Christine.
And the short point is, of course, that the Scottish Government has its own perspective on Brexit, which is that it's against Brexit as a concept and feels that Scotland's not being well protected or represented in the Brexit negotiations. The Scottish Government has published a range of material on how it considers the UK ought to be negotiating in a Brexit context and the asks that the Scottish Government has for those negotiations. And you, again, will have picked up in the politics of this that the Scottish Government and indeed the Welsh Government have had concerns about the extent to which their interests are being taken account of at UK level. And one of the most, I suppose, the greatest manifestation of that concern has come through in legislation that was passed both by the Scottish Parliament and indeed by the Welsh Assembly. So we've talked about the UK EU withdrawal bill. We've talked about the powers that gives to prepare the UK statute book for Brexit. One of the other things that bill does, or that Act now does, is change the devolution settlements for Scotland, Wales and Northern Ireland, and includes provisions about how legislative power is to be divided up around the United Kingdom when we leave the EU. So what happens to powers that currently sit with the EU to regulate particular areas, such as fisheries, agriculture and the environment? Do those powers go to London, or do those powers go to the devolved administrations? Now, it's a complicated and difficult picture. Certainly amendments were made to the UK bill in order to take account of the concerns that had been expressed by Wales and Scotland. Wales accepted the changes that had been made and was prepared to compromise. The Scottish Government did not accept the changes that were made, or was not prepared to accept those changes. And the consequence of all of that has been that there is a bill that has been passed by the Scottish Parliament called the UK Withdrawal from the European Union Legal Continuity Scotland Bill. That's a bill which to some degree replicates what was done by the EU withdrawal bill. That is to say, it confers on Scottish Government and the Scottish Parliament powers to ready the Scottish statute book for Brexit. It goes further in some ways than the UK Act, and it gives the Scottish Parliament and Government powers that the UK says it's not entitled to have. And the upshot of that has been that the bill remains a bill. It has been passed by the Scottish Parliament, but it cannot receive royal assent yet because the UK Government referred its lawfulness to the UK Supreme Court. There's a hearing in July about that, and we're waiting for the Supreme Court's decision on whether or not this bill passed by the Scottish Parliament is or is not lawful and can or cannot be used by the Scottish Government to make the kinds of orders that Charles has already described being made by the UK Government. Now, that's taking us broadly to the end of our formal presentation. One of my colleagues yesterday who attended this seminar in Edinburgh said, but can you not tell people what it is they should be doing in their business to prepare? And I thought that was a very supportive comment to make. The point is, we can't tell you in a forum like this what preparations your business should make, because this is a high level and general seminar, and also because there remains considerable uncertainty. But as Charles has said, there are technical notices published by the UK and by the EU. There is material out there in relation to specific sectors and specific issues. We've written a lot about that, and you can find all of that material on the website or outside. And we're obviously happy to discuss with any of you any of the specific issues that relate to your particular business. But the scope of this session has been to try and give some information about the process and where it might lead. So we're going to move on to the Q&A session. I'm going to ask the kind gentleman at the back to turn off the film. You can now all say exactly what you want to